Hello, everyone. We are back on this gorgeous Thursday to start digging into Bill C-2, the Strong Borders Act. So let's do just that. Now, as mentioned, when we go over these bills, we are looking to see if the following 5 criteria are met. Does the bill address a specific, well-defined problem supported by credible evidence, such as data, unbiased expert analyses, or even public demand? Does the bill uphold public interest and core Canadian principles like equality, fairness, and rights protected under the Canadian Charter of Rights and Freedoms? Are the bill's proposed solutions practical, achievable, and likely to address the problem without creating undue burdens or unintended consequences? Does the bill use the least intrusive means to achieve its goals, respecting individual freedoms and avoiding government overreach? A very important one there. Has the bill been developed through broad, inclusive consultation with stakeholders, meaning citizens, businesses, Indigenous groups, and independent experts? And does it demonstrate sufficient public support? Before we dig into it, though, let's take a minute or so now to listen to MP Anna Sangari introduce the bill on June 5th.
Bill C-2, Mr. Speaker, the Strong Borders Act, will help achieve just that. The bill will keep Canadians safe by ensuring law enforcement has the right tools to keep our borders secure, combat transnational organized crime, stop the flow of illegal fentanyl, and crack down on money laundering. It will bolster our response to increasingly sophisticated criminal networks and enhance the integrity and fairness of our immigration system, all the while protecting Canadians' privacy and charter rights. And let me take a moment, Mr. Speaker, at the outset to talk about some of the safeguards that are in place. As we know, we ran this election. When we ran the election, we did confirm and we reiterated our support for the Canadian Charter of Rights and Freedoms. In fact, it was a previous Liberal Prime Minister and Justice Minister who brought forward the Canadian Charter of Rights and Freedoms. As such, it is a foundational piece of the work that we do. King Charles III, in his speech from the throne last week, reiterated our government's support for the Charter of Rights and Freedoms and the guideposts by which we will work to govern this country. As a result, Mr. Speaker, when we speak about national security legislation that essentially enforces additional tools for law enforcement, it should be with the premise that the rights of Canadians will not be violated. Privacy rights will be protected, charter rights will be protected, and due process will always be there for Canadians.
As you just heard, the Liberal Party takes pride in the fact that it is one of their previous leaders who introduced the Charter of Rights and Freedoms, and it is the foundation of their party. In fact, Carney used this against Poilievre during the federal election English debate. Listen to this clip.
Which is, you have pledged to be the first Prime Minister in this country to use the notwithstanding clause, setting aside charter rights of, as you call them, multiple murderers. Why do you think that's necessary?
To be clear, I want to uphold the charter rights of Canadians under Section 7 to life, liberty, and security of the person. Right now, that right is violated by multiple murderers who are given discounts. The case in question was a gentleman who went into a mosque and shot dead 6 innocent worshippers. He got, according to this ruling, only one 25-year sentence, meaning he can be out in his 50s. He only serves 4 years for every murder that he carried out. That is outrageous. And I will use the constitutional powers that are created for this purpose to ensure that mass murderers stay in maximum security penitentiary for life. They will only come out in a box. We will also pass tough new laws that prevent repeat offenders from getting out. If you commit 3 offenses under the 3 strikes law I propose, you will not be allowed out of jail until you prove that you are drug-free, that you are behaved perfectly and that you've learned an employable skill and you've served a 10-year sentence. We cannot allow liberal crime and chaos to go on terrorizing our communities. What we need is a real plan for change so that we can bring back the safety and the security that Canadians used to take for granted.
Let me get Mr. Carney to respond to that. You think that's an appropriate use of the notwithstanding clause of the Charter?
I think that one of the core responsibilities of the federal government, Prime Minister, is to defend the fundamental rights and liberties of Canadians. And those fundamental rights and liberties of Canadians are outlined in our Charter of Rights and Freedoms, which is 43 years old literally today. I think it's a very dangerous slope to override judgments of the Supreme Court of Canada. In fact, the Charter of Rights and Freedoms exists to protect Canadians from people like us on the stage, politicians who may use their power to override fundamental rights. And the issue in using by the federal government, I'll stop here, is not where you start, but where will you stop?
Mr. Pulley,
There is no confusing these statements. The Liberals claim support and respect of the Charter of Rights and Freedoms, and their leader, Carney, believes it safeguards Canadians from government overreach. Fantastic. That is a great platform. I like the Charter, except for Section 1, but we'll get into that in a later day. So it is safe to say or assume that a bill that a Liberal member would introduce isn't going to infringe on the Charter. So let's get into it. As mentioned, Bill C-2 was introduced in the House of Commons on June 3rd, the very first session of the 45th Parliament. It encompasses 16 parts with amendments to multiple statutes, including the Immigration and Refugee Protection Act, IRPA, Proceeds of Crime, which refers to money laundering, and Terrorist Financing Act, the Criminal Code, and a few others. The bill aims to enhance border security, streamline immigration processes, combat financial crimes, and improve law enforcement's access to data. Key elements include eliminating designated countries of origin for asylum claims, increasing penalties for IRPA violations, prohibiting anonymous financial accounts, and enacting the Supporting Authorized Access to Information Act to mandate electronic service providers, for example, tech firms, to facilitate data access under warrants. The bill's summary highlights reforms to asylum systems, customs, controlled substance regulations, postal services, oceans management, information sharing, financial institution supervision, sex offender registration, and timely data access. It introduces higher monetary penalties, up to $4 million for minor violations, escalating for serious ones. New enforcement tools like compliance orders and transitional provisions for smooth implementation. Schedules amend substance lists and define core providers for data obligations. Okay, as stated by MP Alexis Brunel-Duceppe from the Bloc Québécois, this bill is over 130 pages long, affects more than 3 departments, and could amend some 20 laws. This is the first bill I have ever reviewed in detail, but that seems like a lot, especially with how slow cross-departmental communication happens within our government. But sure, let's write a complex bill that jumps all over departments, amends 20 plus laws. Great idea. Let's go over criteria 1, clear problem identification and evidence. The bill aims to enhance security at the Canada-US border and addresses related issues such as immigration, drug control, money laundering, and data access. The government suggests the bill responds to concerns about border security, asylum system inefficiencies, and financial crimes. But it lacks explicit evidence within the provided text to substantiate these problems. For example, while it amends the Immigration and Refugee Protection Act to eliminate the designated countries of origin regime and increase penalties for violations, no specific data or expert analysis is cited to justify these changes. From a charter perspective, Any restriction on rights, such as mobility and due process, requires robust evidence to avoid infringing on freedoms guaranteed under Section 6 and 7 of the Charter. Without clear statistics or public demand articulated in the text, the bill's foundation appears incredibly weak, risking challenges from unjustified limitations on Charter protected rights. In fact, this trend continues throughout the bill. While problems are well defined at times, the bill lacks embedded, credible evidence. No statistical data is provided. Nothing from Statistics Canada on migration trends, or even FinTrack reports on laundering cases. Expert analyses or references to public demand are not included. Let me say that again. This new bill does not include any expert analyses, which is very interesting. Where do we get expert analyses from? From private consultation firms. Does the government not use our taxpayer dollars for private consultation services? Why, yes, they do. In fact, in the 2023-24 fiscal year, the Canadian government spent $20.7 billion on outsourcing contracts, which included consultations. Interesting. So maybe, just maybe, the money laundering this bill should be focused on is that of our government, because clearly those billions of dollars are not being used on consultation services to help write the bills that are meant to better the lives of Canadians. Kind of odd. So the problems are specific, but no evidence is provided to support the complexity of the problem and the effectiveness of the proposed solutions. Criteria 1, fail. Moving on to criteria 2, alignment with Canadian values. The Strong Borders Act aligns with core principles like public safety, fairness, and rule of law, emphasizing secure borders while upholding humanitarian commitments. Very Canadian. Safeguards such as judicial oversight for warrants and ministerial reviews, support due process under the Canadian Charter of Rights and Freedoms. Yet, tensions arise with equality in Section 15, privacy in Section 4 and 8, and security of the person in Section 7. Let's take a deeper look into Section 4 that recommends amending the Canada Post Corporation Act, CPCA, to enhance border security measures. This section most likely will infringe on Canadian Charter rights and freedoms. Particularly Section 8 of the Charter, protection against unreasonable search and seizure. So the bill modifies or suggests a modification to Section 41.1 to expand the authority of Canada Post and related officials to inspect and seize items in the mail stream, particularly those suspected of containing controlled substances or other prohibited items related to border security. This expansion allows for the examination of mail at international borders or in transit without explicit consent from the sender or recipient, provided there are reasonable grounds to suspect a violation. Critics, including privacy advocates, argue this could constitute an unreasonable search under Section 8 of the Charter, as it lowers the threshold for mail interception without requiring a judicial warrant in all cases, potentially capturing personal correspondence or packages of innocent individuals. The lack of clear safeguards such as mandatory notification or strict proportionality requirements heightens concerns about overreach. Clearly, this is an overreach. While the bill includes protection against liability for good faith actions in Section 26, the absence of robust oversight could challenge Charter compliance, risking privacy violations unless justified under Section 1 of the Charter as a minimal impairment for national security. Although the bill includes reasonable ground thresholds to mitigate overreach, without explicit Charter compliance statements, it risks political overreach of protected rights and freedoms. So, it would appear that the Charter of Rights and Freedoms was not consulted when drafting this bill. Interesting. Listen to this clip from June 5th. MP Michelle Rempel-Garner raises a very important conflict with the bill.
The honourable member for Calgary Nose Hill.
Speaker, if Bill C-2 passes, it would allow CSIS, police, and peace officers to demand personal info from online service providers without a warrant, based only on vague suspicions of potential crime or legal breaches on any act of Parliament. Whether a Canadian uses an online service, where they use it, and when they use it is personal information, and the government has not provided a charter statement for the same. If this bill combined with Bill C-63, the government could target whatever the government deems to be spreading hateful content, and it would combine with C-63 basically to essentially form censorship Voltron. You know, the government has not indicated what policy concerns, aside from vague references to security, these provisions are needed for. These snooping provisions are a massive poison pill that shouldn't have been included in this bill. Why, once again, as they did with C-63, are the Liberals making Canadians choose between their civil liberties and their safety, and also fixing the broken immigration system that the Liberals broke themselves?
Minister of Public Safety.
The bill violates Section 8 of the Charter, which protects against unreasonable searches and seizures by expanding the CPCA inspection powers. Opening mail without clear justification or judicial oversight risks violating privacy rights. It's very simple. As it is currently written, the bill does not specify whether inspections require warrants or are subject to subject to strict criteria. Anna Sangari's comment at the end that this bill was just presented 2 days ago and as such is incomplete and will respect the Charter is completely absurd. Why on earth would you present the bill if it wasn't complete? Either he wants to waste the House's time, i.e. our taxpayer dollars, or the Liberals are trying to sneak one under the rug again. If Bill C-2 and Bill C-3 are approved, freedom of speech is gone. The government will be able to deem anything it wants as hateful speech and punish those who dare speak against the government. No, thank you. Not for me. Off to criteria 2, fail. Now off to criteria 3, feasibility and effectiveness. The bill's measures, such as amending the Immigration Refugee Protection Act to streamline asylum processes and increasing penalties under the Proceeds of and Terrorist Financing Act, appear feasible within Canada's legislative and enforcement frameworks. However, their effectiveness is uncertain due to the lack of detailed implementation plans in the provided text. For instance, authorizing the minister to terminate visa applications in Part 8 could expedite processes, but risks arbitrary decision-making, potentially violating Charter Section 7. The expansion of data access under the Criminal Code in Part 14 is practical with modern technology, but may overburden agencies without clear resource allocation. To respect charter rights, the bill must ensure effective oversight to prevent misuse of powers. Without evidence of pilot programs or impact assessments, the feasibility of achieving security goals without undue charter infringements remains questionable at best, necessitating clearer mechanisms for accountability. Criteria 3, fail. Off to criteria 4, proportionality and minimal intrusion proportionality. Proportionality is critical in respecting the Charter rights, requiring measures to be the least intrusive means to achieve objectives. BC2's provisions, such as enhanced data collection in Part 14 and increased penalties for immigration violations in Part 7, raise concerns about overreach. The Supporting Authorized Access to Information Act in Part 15 establishes frameworks for electronic service providers to share data, infringing on Section 8 of the Charter, protection against unreasonable search and seizure. While border security is a legitimate aim, the bill must demonstrate the least invasive alternatives, like targeted inspections or voluntary compliance programs were considered, but they weren't. The broad powers granted to authorities, such as warrantless data demands, risk excessive intrusion into privacy rights. To align with the Charter principles, the bill needs robust safeguards like judicial oversight and strict data retention limits to ensure proportionality and minimize impacts on individual freedoms. Criteria 4, fail. Now, on to our last criteria, stakeholder support and consultation. Well, we already know this one is a fail, but let's still go through it. Development appears government-led with no explicit consultation details in the text, typical for bills at the first reading. Fine. Provisions suggest input from sectors like immigration, the IRPA tweaks, and the FinTrack enhancements. And alignments with international obligations imply broader consideration. But the document provides no evidence of broad stakeholder consultation. Engaging citizens, Indigenous groups, businesses, and independent expert ensures diverse perspectives, particularly when measures impact rights like privacy and mobility. The bill's amendments to the Immigration and Refugee Protection Act and Criminal Code affect vulnerable populations, such as asylum seekers, yet there is no mention of consultation with refugee advocacy groups or legal experts to assess charter implications. The Supporting Authorized Access to Information Act impacts electronic service providers, but business input is not referenced. Public support is also unclear as the bill lacks data on public demand or approval. For charter compliance, the bill must demonstrate inclusive consultation to avoid arbitrary restrictions on rights. Transparent engagement with stakeholders would strengthen legitimacy and ensure measures reflect Canadian priorities while respecting constitutional protections. So criteria 5, fail. Bill C-2 does address pressing security issues, but fails short in demonstrating clear evidence, charter alignment, and stakeholder engagement. While feasible, its effectiveness and proportionality are uncertain at best without robust safeguards and consultation evidence. To respect the charter, the bill must prioritize transparency, judicial oversight, and minimal intrusion to balance security with rights like privacy, equality, and due process. That last comment that Anada Sangari made, this bill was only introduced 2 days ago. There will be a charter statement coming. And what else? And there will be a robust debate on this issue, is still annoying me. I interpret that as him saying the bill is incomplete and is still missing important content with regard to the charter. So why on earth did they present Bill C-2 so early knowing it wasn't complete? Why not take the time to review it, challenge it against the charter that they claim is the foundation of their party, and make any necessary changes before introducing it? Why didn't they include any data? Were they hoping MPs wouldn't have time to read it and see the cracks? Did they think they wouldn't see the direct link between Bill C-63? If they wanted public support, they should have prepared the bill a little bit more efficiently. So, with all that said, what are your thoughts on this? Because I'm trying to be as neutral as possible, but my allegiance is with Canada and the Charter, but nothing about this bill suggests the Liberal Party cares about the charter they are so proud of. Now, off to answering a question from last episode. At Saturn I-1, you asked how can we convince Liberals to change their mind? We can do this by planting an honest seed of doubt. There are so many people whose core values don't align with the Liberal Party, but they're just unaware of it. They're emotionally driven, and everything they know, their emotions are being driven by the headlines. So all they know is what they've been reading, and it triggers them emotionally. And then if you go and attack them and say Carney's a big old liar who's a globalist and wants essentially to sell off Canada for parts, the walls are just going to go up. So you can't attack a Liberal supporter through debate. And honestly, debates aren't meant for you to win an argument. A debate, when you're debating someone, you're trying to win the crowd, not convince the opponent that they're wrong. And the best way to do that is planting honest seeds of doubt. So this Bill C-2 is a perfect example of that, of, hey, the Liberals support the charter. They say it's the foundation of their party, yet they are proposing a bill that is going to allow them to go through your mail out of suspicion. No judicial process. They can just do that. That kind of conflicts with Section 8. What do you think about that? Plant seeds. The Liberal platform is so weak and their actions conflict what they say. So just point it out. Hey, they want to do this. Yeah, I'm seeing this. What are your thoughts on it? Don't argue, don't say you're wrong, because walls are just going to be built up. We're going up against walls and we have to bring them down. And the best way, in my opinion, to do that is to enter a conversation with your opponent, ask questions, get them to answer, find the cracks, but do it with compassion, do it with kindness. Don't do it as an attack on who they are. They're just a product of our nation, and our nation is a bunch of politically illiterate individuals. Bless their hearts. I was one of them. I still kind of am. Like, I am, with every episode, I'm learning more and more. Like, I am by no means an expert of the government or the history of Canada, but the more I learn, the more questions I ask. And that's personally how I kind of became aware of the Liberal platform and all of their lies, to be honest. So that's what I would do. Plant seeds of doubt. I hope that helps. And if it doesn't, maybe we can try and find a better way to convince people to open up their ears a little bit more. And on that note, this was a very long episode. Well, for my standards anyways. So hopefully it wasn't too long and you enjoyed it. And I will see you guys on Saturday. Take care, everyone. Bye-bye.